This is an appeal against a legal services payment order. I'll use the acronym LSPO, made pursuant to Section 22ZA of the Matrimonial Causes Act 1973 by Sir Jonathan Cohen, the judge sitting in the Family Division of the High Court on 13th December 2024. By his order, he required the husband to pay the wife a total of $120,000 plus VAT, $72,000 of which was payable by the 15th of January 2025 and $48,000 by the 15th of February. He also ordered the husband to pay the costs of the application summarily assessed by him at $20,000 plus VAT. The LSPO was made in the context of long-running financial remedy proceedings in which the judge had made a final order in December 2023. Its purpose is to enable the wife to obtain legal services in respect of appeals from that final order being pursued by the husband and an intervener, IIB Group Holdings WLL, IBB. Those appeals are listed for hearing on 11th and 12th March 2025. By his appeal, the husband seeks to challenge, or by that appeal, the husband seeks to challenge the judge's finding that he had approximately £16 million in a bank account in 2020, and that it was probable that at least some or a significant part of that amount remained available to the husband, what I will call the challenged finding. By its appeal, IBB challenges a provision in the judge's order, to which I will refer later. Although Ms. Bangay sought to extend the scope of the appeal during the course of the hearing, the ground for which permission was granted related only to the judge's approach to the challenge finding. In essence, it was contended that the judge had wrongly taken this finding into account when determining the wife's application. I should add that there were two other grounds of appeal for which I refused permission. In response, the wife contends that the judge was entitled to take the challenge finding into account and that there is no basis on which we could properly interfere with the exercise of his discretionary power. In the alternative, she has filed a respondent's notice seeking to uphold the judge's order for additional reasons. This appeal has been expedited because, as I've indicated, it relates to the funding of the linked appeals which are due to be heard on 11th and 12th of March. Having regard to the need for expedition, my judgment, or this judgment of the court, the court's judgments in determining this appeal are also being given extempore. On this appeal, or at this hearing, the husband is represented by Ms. Bangay, King's Counsel, as he was below, and the wife is represented by Mr. Sirikanda, acting pro bono, and Mr. Haggie, who also appeared below. The history of the financial remedy proceedings from which this appeal arises can be stated briefly for the purposes of this appeal. The parties cohabited from the start of 2012 and married in April 2013. There is one child of the marriage. The wife commenced financial remedy proceedings in December 2020. The proceedings were transferred to the High Court in July 2021 and have been dealt with since then by the judge. IBB, a holding company in which the husband is the majority shareholder, was joined to the proceedings in December 2021 because they were a party to a disputed transaction. All three, i.e. the husband, the wife and IBB, have been represented throughout their involvement in these proceedings. A significant issue in the proceedings was whether, as alleged by the wife, the husband had failed to disclose significant assets. The final hearing took place before the judge between 16th and 23rd October 2023, and his judgment was delivered on 28th November 2023. As referred to already, the judge found that the husband had approximately £16 million available in accounts with IIB in 2020. Because of the husband's deficient disclosure, he did not, I quote, know where the money came from or where it is now, but that there is some at least of it left is probable. The judge's summary of the parties' assets and liabilities was as follows, and I've taken this from his substantive judgment. A property in Portugal in the wife's name, I believe, with an uncertain value. This has since been sold for €325,000, a substantial part of which has been paid to the wife's litigation funders. The husband's savings of £16 million, as per the November 2020 letter, and I quote from the judgment, wherever and in whatever sum they may now be. The husband's interest in IIB, which had a value of some £7.5 million. A debt owed by GA, using the initials from the judgment, of $25 million, I quote, with all its uncertainty as to payment. The only secured sum is the £1.5 million equity in the Knightsbridge property. The wife had liabilities, a litigation loan then of some £1.7 million, including interest, and unpaid costs of just over £700,000. And the husband's liabilities were that he owed his father £465,000 and his solicitors just over £630,000. The husband's net and gross income were approximately $425,000 per year. The judge ordered the husband to pay the wife a lump sum of £6 million, as well as spousal and child periodical payments. He also included within his order a provision that, I quote, the parties shall endeavour to agree the terms of the purchase of the replacement property in accordance with paragraphs 130 to 131 of the judgment. In the event that the parties are unable to agree such terms, there be liberty to the parties to apply to the court for adjudication on issues on which they disagree, end quote. The husband has been given permission to appeal against, in essence, the challenged finding, which it is submitted was the foundation for his lump sum order. In support of his appeal, he also seeks to rely on fresh or new evidence for which permission has not yet been granted. IIB has also been given permission to appeal against the provision to which I have just referred, submitting that the judge did not have jurisdiction to order them, in effect, to provide a property for the wife. I should add that those substantive orders, not the maintenance, but the substantive orders to which I've just referred, have been stayed pending determination of the respective appeals. On 13th August 2024, the wife filed an application for a legal services payment order pursuant to Section 22ZA of the Matrimonial Causes Act in respect of her prospective costs of responding to the listed appeals. She applied for a total of £212,000 plus VAT. The application was accompanied by a statement from the wife of the same date. The husband's statement in reply is dated 4th December 2024. In the course of that, the husband said that, I quote, there now exists better evidence in respect of the non-existence of the 16 million, which is the subject of an application to admit fresh evidence, end quote. He contended that the fresh evidence, I quote, provides a comprehensive answer to the questions posed by the judge at paragraph 93, end quote, of his substantive judgment. These were questions the judge had posed in the course of considering whether the husband had had accounts containing 16 million in 2020, as set out in 2 letters from a director of IIB to the husband. The husband exhibited to that statement letters from Ernst & Young and PwC, which he relied on in seeking to meet a point the judge had made during the course of his substantive judgment, namely that the reports provided by accountants had been, I quote, dependent on the material provided to them by the husband/the bank, and, I interpolate, I note, more importantly, their inquiry was not on joint instruction, but commissioned by the wrongdoers and has not been the subject of scrutiny, end quote. The husband contended that the new evidence showed that the accountants had had, I quote, full unrestricted access to all underlying materials on which to prepare, end quote, their reports. The wife's position was that she required an LSPO because without such an order, she would not be able to obtain any legal services for the purposes of the appeals. To date, she has funded her legal representation largely by way of a loan from litigation funders, which we were told currently stands at just over £2 million. In addition, the wife owes her solicitor a further sum of, it would appear, just under £1 million. The wife's application came before the judge on 13th December 2024. The wife submitted that the husband had the means to fund her costs of the prospective appeals. The husband's position before the judge was that he did not have funds to provide for an LSPO. He said that the judge's findings were disputed by the very appeal which the wife sought funding to defend, and therefore could not be relied upon by the judge to justify making an order. The husband also said that he did not have funds to pay for his own appeal and was only able to bring the appeal on account of the, as he described it, the generosity of his solicitors, who had agreed to continue to act for him on the basis that he was an important client of theirs and would repay their fees in the future. The judge gave an extempore judgment. We have an approved transcript. The judge started by observing that the case, I quote, has rightly been described as catastrophic for the parties, and the amount that they have incurred in legal costs is appalling, end quote. He then addressed the challenge finding, and I quote from his judgment starting at paragraph 3. There is a sort of element of unreality about this hearing, because the fact is, I found that the husband was the owner of accounts which held a very significant sum in them, approximately 20 million. This should, I think, be 16 million, but the difference is immaterial. I ordered him to pay a lump sum of £6 million. As I said in the judgment, I did not know where that money was, and I did not know how it had been utilised. On the balance of probabilities, I found that he still had a significant part of that money. He has obtained permission to appeal that order. Nevertheless, that is what my finding was. Paragraph 4. I accept that he challenges that finding. He says that I was wrong to so find, and he wishes to put before the Court of Appeal a mass of new evidence that he has obtained. He has set out the gist of it in his statement. I have not been asked to go further by looking at the underlying documents. The gist is, he says, there never was that sum of money for him. It was all made up for the purposes of trying to secure a commercial deal. Well, that is for another court to rule upon, end quote. The judge was, I quote, clear that the wife in this case does not have funds from which she can fund her costs of the appeal. Later, then when dealing specifically with Section 22ZA of the 1973 Act, the judge repeated this finding. I refused the husband's application for permission to appeal in respect of that part of the judge's determination. The judge continued later in his judgment, paragraph 12. I turn next to the other matters which statute requires me to look at. The second one, and equally important of course, is the financial circumstances of the respondent, who says that broadly speaking, his position is the same as it was when he was before me for the substantive trial, save that his expenditure has gone up for various reasons, which are perfectly proper, and which are set out in his statement. 13. Mr. Haggie, who appeared as junior counsel at trial and appears on his own today, set out various matters from which he asked me to draw conclusions based upon the recent accounts of IIB, which employs the husband and which is largely owned by him. I do not think it would be proper for me to draw the conclusions that he asked me to draw. What I think he can properly say is that insofar as funds have been required of the husband for his costs, some of them for applications which should never have been brought, he has always found the funds. Of course, he has also continued to his credit to pay maintenance at the rate that has been ordered. He has managed to meet certain of his other obligations, and he has incurred significant indebtedness to his solicitors, who are apparently prepared to play the long game and also to his father, end quote. The judge then concluded, I quote paragraph 14, "Then I come back to the findings that I made, and I am entitled to take them into account. I cannot simply put them aside, as Miss Bangay asked me to do. I have to put this wife in a position where she can argue why the substantive appeal should be dismissed. It would be doing her a grave injustice if I was to permit the situation where the husband and IIB were represented and she was not, particularly against the background of the findings that I have made," end quote. At the end of his judgment, the judge added, paragraph 18, "I have not forgotten Miss Bangay's argument that the wife's refusal to enter into negotiation should count against her. In the case where the parties are so far apart, it is very difficult to see what the way forward is. I do urge the parties to enter into negotiations, and I indicated to them one possible route which they might wish to consider. I do not think in the circumstances that it would be right to penalise her for her solicitor's response to the letter I was referred to. I do urge the parties not to give up on discussions," end quote. The husband's application for permission to appeal in respect of the LSPO was refused by the judge after the hearing. On 15th January 2025, I stayed the LSPO pending a determination of the husband's application for permission to appeal. On 12th February 2025, I granted permission to appeal in respect of ground 1 only. As I've already explained, this hearing has been expedited. As encapsulated in the husband's skeleton, the effect of ground 1 is as follows, I quote, "It is self-evident that the judge could identify no source from which the husband could pay an LSPO order to the wife other than from the disputed account. In placing wholesale reliance on his finding that the husband had an account with IIB, he was wrong to do so, and to award the wife an LSPO from that source which is under challenge at the appeal. Such an approach was circular and wrong," end quote. In deference to the submissions made by Miss Bangay today, I set out ground 1 as it appears in the grounds of appeal in a little more detail. Starting at paragraph 10 of those grounds. In determining the wife's LSPO application, the judge found that he had to remain faithful to his finding that the husband had the disputed account and thus access to cash of 12 million plus pounds available to him, which is the very finding under appeal. He refused to consider and or to take into account the husband's application to the Court of Appeal to admit fresh evidence, the essence of which is the husband has never had any accounts with IIB, albeit he accepted that the summary in the husband's witness statement setting out what the evidence showed was an accurate reflection of that evidence. He, however, stated that this was for determination by another court on another day, paragraph 11. The judge asserted that having made such findings about the disputed account, he was entitled to rely and base his LSPO award on such findings. 12. Therefore, the judge decided that the husband could afford to pay an LSPO award to the wife, which he assessed in the sum of 120,000 plus VAT to be paid from the disputed account. 13 deals with the form of the order. 14, where the very existence of these claimed funds will be considered at the March 2025 appeal hearing, such finding was plainly wrong. In paragraph 15, it said that the judge did not take issue with certain aspects of the husband's evidence, which are then set out. And in paragraph 16, it was asserted the judge's decision that the husband should pay the LSPO and costs from the disputed account, where the husband was in a parlous financial position and unable to fund even his own lawyers, was perverse and creates a circular argument as to the existence of the disputed account. In response, the wife relies on the following points, which I take from her skeleton argument. A, the well-established legal position which the judge implicitly adopted is that a prospective appeal does not alter the validity of any order nor any factual findings. The judge was fully entitled to attach weight to all, I emphasize, of the findings he had made, including the disputed accounts. Including that the disputed accounts had existed with millions of pounds which had belonged to the husband. B, the proper approach to a post-final hearing LSPO application for appeal costs is that the trial judge should balance the effect and import of his findings against the fact the litigant has exercised their right to appeal, and if applicable, the permission to appeal has been granted, and exercise the discretion conferred by Section 22ZA accordingly. That is what the judge did in this case. C, in any event, ground 1 is misconceived because it proceeds on the incorrect premise that the finding in relation to the disputed account was the sole basis of the LSPO award, when in fact a proper reading of the judgment is the judge took into account all his findings, which included the husband's admitted lies, and placed equal weight on the husband's evident ability to find money to meet obligations, including his obligations to pay counsel, as set out in the skeleton argument. It was further submitted, and again I quote, in the absence of any previous binding authority, it is submitted that the judge adopted the correct method of exercising his discretion. That exercise involves having regard to the statutory factors in Section 22ZB of the 1973 Act, but also, we submit, an analogous exercise to that undertaken on an application for a stay as set out in Hammond, Sudard Solicitors and Agrichem. Paragraph 22 from that decision is quoted, and I quote, whether the court should exercise its discretion to grant a stay will depend upon all the circumstances of the case, but the essential question is whether there is a risk of injustice to one or other of both parties if it grants or refuses a stay, end quote. Mr. Sirikanda drew specific attention to the judge's reference to his findings, and he emphasized the S. I quote from the skeleton argument again. The judge was, he submitted, entitled to take into account his findings, including his finding in respect of the disputed account, even though it was subject to appeal. It would be wholly unreal to ask him to do otherwise, but he was aware throughout the judgment that there was to be a hearing of an appeal where that finding was subject to challenge. It was submitted that the judge rightly balanced the findings against the fact of the appeal and concluded that there would be a grave injustice to the wife if an order was not made, and that she would not be able to defend the appeal and seek to uphold the finding, and would face the husband's leading counsel as a litigant in person in the Court of Appeal. The relevant legal framework can be summarised briefly. It's accepted that a judgment and order remain effective until set aside. The jurisdiction for making an LSPO order is provided by Section 22ZA. Subparagraph 3 provides the court must not make an order under this section unless it is satisfied that, without the amount, the applicant would not reasonably be able to obtain appropriate legal services for the purposes of the proceedings or any part of the proceedings. Subparagraph 4. For the purposes of subsection 3, the court must be satisfied in particular that A, the applicant is not reasonably able to secure a loan to pay for the services, and subparagraph B refers to the possibility of a charge. The matters to which the court must have regard when deciding whether to make an order are set out in Section 22ZB. I do not propose to set them all out in this short judgment. I refer only to 1C, I quote, the subject matter of the proceedings, including the matters in issue. D, whether the paying party is legally represented in the proceedings. H, the effect of the order or variation on the paying party, and subsection 3, which provides additionally that, I quote, for the purposes of subsection 1H, the court must have regard, in particular, to whether the making or variation of the order is likely to A, cause undue hardship to the paying party, or B, prevent the paying party from obtaining legal services for the purposes of the proceedings, end quote. I propose only briefly to summarise the parties' oral submissions today. During the course of her submissions, Ms. Bangay sought, as I have already referred to expand her appeal into matters not covered by Ground 1, for which she was given permission. For example, she submitted the judge had failed to consider Section 22ZB3A, namely the issue of undue hardship. This and the other points she raised were not referred to in either Ground 1 or the skeleton argument, and in my view it would be wrong to permit the scope of the appeal to be expanded in that way. Ms. Bangay's primary submission was that the judge was wrong to base his decision on the challenge finding. In doing so, the judge, I quote, ignored, end quote, the fact that the husband had been given permission to appeal and that a stay had been granted of the substantive capital order, and, I quote again, ignored the husband's fresh evidence. The judge gave, I quote, no weight whatsoever, end quote, to these factors and, I quote, effectively ignored or put to one side even the prospect of the husband's appeal succeeding, end quote. Ms. Bangay accepted during the course of the hearing that she could not submit that the fresh evidence would establish that the judge's challenge finding was fatally flawed or that the husband's appeal would succeed. What she submitted the judge should have said was, or the task he should have undertaken was, I quote, while I recognise I made the finding, there is legitimate evidence when viewed objectively which may result in that finding being overturned, end quote. Additionally, Ms. Bangay submitted that the judge insufficiently considered these matters. In support of this submission, she referred to Section 22ZB1C, which requires a judge to have regard to the matters in issue in the proceedings. This, she submitted, required the judge to undertake a more detailed assessment of the evidence on which the husband relied and on the merits of his prospective appeal than the judge did. Her subsidiary submission was that the judge gave these matters insufficient weight. Ms. Bangay finally submitted that there was a grave risk of potential injustice to the husband if this appeal was not allowed. Mr. Sirikanda followed the course of his submissions as made in the skeleton argument. He submitted the judge was entitled to take the challenge finding into account and did not fall into error by doing so. He relied on the fact that a judgment or order stand until set aside. The party was, he submitted, entitled to rely on the court's judgment and its findings, even though they were subject to appeal. It would be wrong and unfair to that party to do otherwise. Secondly, he submitted that, as the judge determined, it would have been wrong for him, as proposed by the husband, simply to put his findings aside. The judge had to balance the relevant factors, which included all the findings he had made in his substantive judgment, including, specifically, that the husband had lied, as well as the challenge finding, and the fact that the husband had been given permission to appeal. The judge was also entitled to take into account the manner in which the husband had, I quote, always found the funds, end quote, to meet his own costs, at least to a substantial extent. In respect to the husband's fresh evidence, Mr. Sirikanda submitted the judge can be seen to have taken this into account, as set out in paragraph 4 of his judgment. The judge had to consider the balance of justice in a similar manner to the way in which this is undertaken when the court is considering whether to grant a stay. In summary, Mr. Sirikanda submitted that the judge's decision was unassailable. I can give my reasons for determining this appeal shortly. As rightly accepted by Ms. Bangay in her submissions today, there are limited grounds on which an appeal court is entitled to interfere with the trial judge's discretionary decision. In very brief summary, it must be shown that he made an error of law or that his decision was wrong in the sense of being a rationally unsupportable decision. I have been persuaded by the wife's submissions that the judge made no error which would entitle this court to interfere with his decision. I reject the submission that the judge was wrong to rely on the challenge finding. The fact that it was subject to an appeal does not mean that the judge should have excluded it from his consideration, a proposition with which I think Ms. Bangay agreed during her oral submissions today. I do not accept her submission that the judge ignored the fact of the appeal or that he ignored the fresh evidence. The judge was plainly aware of both of these factors and, in my view, equally plainly took them into account. He expressly referred to them both in the course of his judgment. I acknowledge that he did so briefly, but I do not consider that for the purposes of his decision, he was required, as Ms. Bangay submitted, to undertake a more detailed assessment of the evidence on which the husband relied, or of the merits of his prospective appeal than he did. I also do not consider that, as submitted by Ms. Bangay, the judge's decision was circular and wrong because it placed wholesale reliance on his finding as to the 16 million. The judge did not place wholesale or sole reliance on this finding. He referred more than once to his findings, which included other matters to which I have referred. As to his challenge finding, the judge did no more than, as he said at paragraph 14, take this into account. Further, in my view, the judge had to consider, in accordance with, among other matters, the overriding objective, the balance of justice or injustice or the balance of prejudice when deciding what order to make. This included deciding what weight he could properly put on the challenge findings and the other matters relied on by the parties. The situation is not entirely analogous to an application for a stay, but it is in similar territory. Accordingly, I consider, as again I think Ms. Bangay accepted, indeed probably or possibly submitted, that the judge was right to consider the risk of injustice when deciding whether to make an order. As part of this, it would have been wrong for him simply to ignore the challenge finding, as it would have been wrong for him to ignore the fact that permission to appeal that finding had been granted. The judge had, therefore, to consider the balance of prejudice when deciding what weight could fairly be applied to the challenge finding. In this case, the judge was plainly entitled to decide that it would cause the wife a grave injustice if he was to permit the husband an IIB to be represented, but the wife not. Finally, insofar as Ms. Bangay sought to challenge the weight the judge gave to the challenge findings and the other matters as advanced in her oral submissions today, there is no basis on which we could properly conclude that the judge did not give appropriate weight to all the relevant factors. In conclusion, in my view, the judge made no error of law, and his decision was neither wrong nor rationally insupportable. Accordingly, I would propose that this appeal be dismissed.
I agree. I also agree.
Yes.
My Lord, I'm sure Mr. Stuart-Smith is anxious to make a cost application, but may I just deal with one matter?
Yes.
I'm conscious of the hour. That is to ask your Lordships to consider an application for a stay on enforcement of the LSPO award. I understand, my Lord, from my recent researches that this court has an unfettered discretion to grant a stay, and as we saw from the authority that your Lordships have been referred to, the Hammond case, the proper approach is one which best accords with the interests of justice. And, my Lord, there is a significant risk here that if the order was not stayed and there are enforcement proceedings, that my client's ability to pursue the appeal is likely to be stifled because of the advertised Hodkinson application. Lord, it's for those reasons that I invite your lordships to grant a stay pending determination of the substantive appeals.
Right, thank you.
My Lord, Mr. Haggie is going to address the court on consequential matters.
Right, thank you. Yes, Mr. Haggie.
Dealing with that application, our first observation is that there's no live appeal extant against the LSPO order, and it would be unfair, therefore, to stay the effect on that. Secondly, taking the question more generally of the balance of injustice between the parties, your Lordship has just dismissed the challenge to the underlying order, which Sir Jonathan Cohen concluded was necessary for the wife to really access legal services, and there would be a grave injustice to her if she was not represented. That was a deal on one ground, which you've just dismissed. The effect of the stay, if made, would be to revive that grave injustice to the wife, and clearly, in applying that test, the balance clearly falls against ordering a stay of the
Thank you. Yes. Any other matters?
We would seek that the payment of the sum, assuming you don't stay it, is paid by 4 p.m. this coming Monday. As we set out in our skeleton, council are not going to act in this case without funds on account. We would then propose lodging our skeleton by Friday, forgive me, the 7th of March. That's very shortly before the appeal, but we find ourselves where we are through no fault of our own.
Can you remind what's the date on Monday?
24th.
Monday's the 24th.
24th. And how long after the 24th is the 7th?
That's 2 weeks, effectively. 10 working days.
Right.
What I further submit to your lordships is that if the sum is not paid by the 24th, this court makes effectively an unless order. Not that the appeal is struck out, but that the appeal is adjourned. If we're not in funds, the wife will be considering her enforcement position. She won't be engaging with the appeal. We will be applying to this court, not necessarily for a hag concern, although we don't take that off the table either, but certainly to adjourn the appeal so we can consider our enforcement position and engage substantively with it. That application, at the very least, is inevitable if this sum is not paid. If we spend the next 2 weeks ahead of this appeal dealing with enforcement, not with the skeleton, there's no chance that we're going to be effectively in a position to engage with your lordships on the 11th of March in any event. That order effectively saves an application, certainly as far as the husband's appeal is concerned. I appreciate IIB up here before you today to consider their own position.
Right.
But we would suggest that is a pragmatic, consequential order that deals with what is now inevitably quite an imperiled appeal.
If you go down this path, assuming the husband doesn't pay, and you bring enforcement proceedings, it would be open to the. Would it be open to the husband in those circumstances to assert on the basis of evidence that he does not have the money?
If we brought an enforcement claim against him, it would depend on the form of enforcement we brought. If we brought a judgment summons, we would have to prove to the criminal standard, effectively, that he didn't have the means to pay, and he would be entitled to raise his defence as he saw fit. If we issued a statutory demand on the basis of the outstanding cost order,
I'm just thinking, you couldn't rely on a res judicata issue where the disputed accounts are subject to an appeal, could you?
no, that's correct, and we could.
So, I mean, what you're going to get, if you do try to enforce, I'm not saying you shouldn't, but what's going to happen, as it seems to me, what's inevitably going to happen, is that the husband will marshal all his evidence to say, I haven't got the money. And the person charged with the enviable task of deciding whether to enforce or not will have to take that into account or accept it or reject it as it may be.
We would be entitled to rely on the judgment below, I would suggest. And secondly, whether or not the disputed account was a central feature of an enforcement application would turn to some extent on the manner of the enforcement application that we brought. And
So
it would be a fact-sensitive exercise depending on where we got to. Sorry, my lord.
But the unless order is only in respect to the husband's appeal.
I can't see how I can fairly bring IIB into that today, given they're not here to answer it.
Okay, thank you.
But certainly the assumption for all of these appeals so far has been that they will be heard together, and I imagine IIB would consider their position if that order was made.
Yes, anything else?
We will make an application for costs.
Today?
Yes, whether we seek to be summarily assessed.
Have we got any forms?
A costs budget, a costs form was lodged with the court. I don't think it's in the bundle, but it's...
I don't think it is. I don't think I've seen it. So have you got a copy?
Do we have a printer?
We've certainly got a costs schedule or whatever from someone yesterday, but it might have been from...
Might have been asked.
That was you.
Have you got three? I'm glad to say we've got some paper copies which I'll hand out. These were lodged yesterday, I believe.
Ms. Bangor, do you have any paper copies of yours for me?
I don't know.
No,
Do you
okay.
have any?
I don't know if
No,
I've seen-
I've certainly got mine in soft copy.
Yeah, thank you. Thank you. Can you just tell me what your... Sorry, go on, yes.
I'll let you talk.
No, go on, finish.
Well, it's a very basic submission, which is that we've been successful in defending the appeal, which
Yes.
has otherwise been meritless, as it turns out. Cost should follow the event. On that basis alone, we seek them to be summarily assessed.
Thank you, yes. Ms. Bangor.
Can I deal with the stay point first?
Certainly.
Lord, as I understand it, under Senior Courts Act section 49(3), nothing in this act shall affect the power of the Court of Appeal or the High Court to stay any proceedings before it, where it thinks fit to do so, either of its own motion or on the application of any person, whether or not a party to the proceedings. My Lord, you have been made fully aware of my client's financial position. Come Monday, my client will find himself between a rock and a hard place because my very clear instructions are, as they have been throughout, that he is not in a position to raise the monies to pay the costs. So can we proceed on the basis that he is more unlikely than not to pay those costs on Monday? What is clear here, as your lordships have heard during the course of submissions, is that the costs in this case have been catastrophic. And for there to have to contemplate yet further proceedings for enforcement, whether they be by way of a judgment summons, by way of a statutory demand, those proceedings are likely to take many, many weeks before they come to fruition. And as your lordship has astutely observed, then the court will have to take into account, in effect, the evidence that the husband will be producing on the appeal.
Thank you, yes.
What these parties need to do, my lord, is to have this appeal determined. What my client can't afford to do is pay those costs in advance of the appeal. So
Okay.
I do invite your lordships to stay the payment of that order until the determination of the appeal.
So far as the timing is concerned, as put forward by Mr. Haggie, he was saying Monday the 24th, and the skeleton, assuming the monies are paid, by Friday the
Well,
7th.
my lord, it's not just a skeleton, because, again, it's been advertised by the wife that she's going to be serving a respondent's notice in respect to the IIB appeal, that she is going to be alleging that the judge should have found it was a sham. So there are some very significant arguments to prepare for. My lord, 3 days before an appeal is insufficient for us to, as it were, to consider and prepare an appropriate response. So, my lord, they should have no more than 7 days to prepare their skeleton arguments.
I haven't got the calendar in front of me. 7 days from the 24th. What's the following Monday?
It would be the 24th. Mr. Sari will tell me.
3rd of March.
3rd
3rd of March.
Right, thank you. And the other provision thought that unless the costs are paid by Monday, 4 o'clock on Monday the 24th of February, the hearing of your client's appeal is adjourned.
Well, my lord, we're just kicking into the long grass, a problem that isn't going to go away. all that it means is that these parties are going to dig themselves deeper and deeper into debt. And what this court needs to do is to determine these appeals in respect of an order that was made back in November 2023.
And costs?
My Lord, we are, to put it politely, astonished by the level of costs incurred by the wife's solicitors, bearing in mind that your Lordship only gave permission a week ago. And when your Lordship looks at the breakdown of the work that was done, I think it's on the last page.
Could you tell me what your, because I haven't got the form, could you just tell me what your total costs are?
They're 38,000, my Lord. And that is, of course, is including the fact that we've had to do all the running in this appeal, both the notice, the grounds, skeleton.
So that's 38,000 excluding VAT.
Excluding VAT.
This is 46,000
Yes.
including. So in fact, they're identical.
Well, they are, my Lord, but we just simply don't understand how this appeal, which has only been on the stocks for a week, how these solicitors, if your Lordship looks at the breakdown of their costs, could have spent some £20,000 in a week. If your Lordship goes to the very last page.
The hours, yes.
Preparing for hearing, it is just quite extraordinary, my Lord.
Well, it's the thing that jumps out is 18 and a half hours for the associate.
Well,
In circumstances, whereas I understand it, the skeleton and drafting was done by council,
well,
or largely done by council.
well, that's right, my Lord, but also even in the first category, considering options regarding LSPO and litigation strategy to include merits, 2,302, when council have been, as it were, in charge of that. And then we have considering settlement position relevant to the LSP. There have been no settlement proposals from the wife in respect of the LSPO. And then considering response to the appeal, 1,400. All these items add up. And then amending and finalising correspondence with the applicant to include advice, £1,500. And then, as your Lordship said, preparing for hearing, £10,000. My Lord, we simply don't understand how these costs can have been occurred in what is in effect some 4 to 5 working days. And they are, we say, simply not supportable. I don't take issue with Mr. Haggie's fee, although he is charging more than me today. And so, my Lord, we say that their costs are excessive.
Sorry, can you give me the breakdown of your 38,000 then? The solicitor's costs are...
Could your Lordship just bear with me?
Yeah,
I don't
sure.
have a hard copy and I have to... there we go. It is solicitor's costs, 11,250.
Sorry, yes.
Fees for the preparing of the appeal documents by counsel, 13,800. Fee for this hearing, 7,500 plus court fees. Oh, it's a total of 32,435.
Sorry, what are the court fees?
626 and 259. And the total is 32,435.
Not 38.
No, I was wrong.
Thank you. Thanks very much. Okay. Do you want to say anything in response on the quantum?
Yes, my Lord, just briefly dealing with my learned friend's suggestion that we should file a full skeleton in this by next Friday. I think it was the 28th.
No, it was the 3rd. It was Monday week.
Sorry, forgive me. Well, over the course of the next working week, I thought already the most optimistic possible deadline for filing a skeleton in this case from where we are now. And I do stress that we're here through no fault of our own. We made our application for the last one on the 13th of August. It was meritorious. It was heard 3 months later on the 13th of December. We've since had to deal with this appeal. There were times where we could have dealt with this in a more timely fashion. None of that is the wife's fault. 2 weeks is the absolute minimum that is required. Mr. Glazer, I understand, has professional commitments. He's not here today because he's away. I understand he's got commitments over the next couple of weeks. So that, in my submission, is a non-starter. I didn't want to shadow box whether or not we bring an appeal out of time against the FAP decision, because if we bring that, we will have to cross that bridge in due course.
Yes.
But that, of course, is something that will need to be considered as and when it happens. On quantum, the first observation is the parties' figures are broadly similar. You have to factor in VAT on our side, which brings it higher. It's not a fair observation to say we've incurred this in the last 4 days. The appeal was brought on the 17th of December. The costs reflect consideration of it since that time and work since that time. Ms. Bangay is significantly more expensive than me overall. She's charged almost £14,000 for a conference, as well as her fee today. Our counsel's fee is in the round and includes me drafting the reply to her permission application, the Jolly and J note, which hopefully found its way to you. I understand from those who instruct me that the reason there's more fee earners on this than you'd expect is because certainly in the last week we've been caught a little bit on the hop. Lots of people have been on holiday. Mr. Evans was away, that sits behind me, who's most familiar with this case. Others have covered for him. There has been time incurred. Only 2 of the 3 solicitors today are billing. Standing back, and certainly by reference to what the husband has charged, the fee overall is a fair assessment of what has been incurred on this.
Thank you. We'll rise for a few moments.
Rock and roll place, aren't we? If the appeal goes off, what happens then? It can't be argued. Because it covers her husband.
It might.
His acceptance, they can't come unless we bring the bank. So, banks want to go ahead.
Well, I won't be there.
No.
James can do it.
And then the banks will go ahead and they win. We're going to take them out on the house.
He won't. In terms of enforcement, we need to target prove.
I'm just going to delay the other day, get out of the diaries and never come. Just sit there. Don't spend money on enforcement.
Watch the brief. Watching the brief.
Stat demand. We could put the 6 million debt in the bankruptcy.
Dealing with the consequential matters, first of all, the application for a stay of the substantive LSPO order. Frankly, and putting it very simply, it would be inconsistent having dismissed the appeal from the LSP order to grant a stay, because that would, in essence, have the effect as though the appeal had been allowed. So we refuse the application for stay of the LSP order. We're going to provide that the total sum due under that order should be paid by 4 o'clock on Monday, the 24th of February. And the parties will have to draw up and draw up this order and send it to Please My Clerk. So far as the wife's skeleton in respect of the appeals listed for 11th of March, that is to be filed by 4 p.m. on Wednesday the 5th, if I got the right date, of March. Leaving it to Friday the 7th is too late. We don't propose to make an unless order as sought, that if it's not paid, the hearing is adjourned. Any application as to any consequential matters thereafter will have to be addressed separately. So far as costs are concerned, we are going to make an order that the husband pay the wife's costs of this appeal. She is the successful party and there is no reason why costs should not follow the event. And we propose to summarily assess them in the amount of £25,000 plus VAT. So thank you very much. And as I say, can you draft the order and send it to my clerk? Thank you.